This is the second half of the first cassette on Basic Federal Practice, the Essentials of Civil Pretrial Procedure in Federal Court.
You should also know that once the complaint is filed and the counterclaims are filed and cross-claims are filed and there are multiple parties before the court and you're there because you have claimed originally its diversity, the court has the power and the obligation to try to align those parties to put them where their interests actually are, rather than just how they happen to be designated as plaintiffs, defendants, counterclaimants, counter-defendants in the action. So just naming someone a plaintiff or defendant may not be the end of the inquiry for purposes of diversity jurisdiction. Again, I would refer you to the treatises if you have specific questions about either federal subject matter jurisdiction based on federal questions or based on diversity jurisdiction. You should be aware that there's another kind of federal jurisdiction that really is a way to pursue the interests that Boris mentioned, and that is to make sure that the case that is before the federal court is the entire case and that the entire case can be resolved. And that's a rule of pendant or ancillary jurisdiction. Those are the terms that happen to be used. And those terms permit the federal court to not only to resolve the federal claims and the diversity claims that are before it in federal claims, but also state court claims. Let me give you an example. If you have a patent case, which is a federal question claim brought under a federal statute, you can include in that case a state law breach of contract claim or some other state claim. How do you do that? You do it because the federal court may exercise pendant or ancillary jurisdiction over these claims. You can also take a look at the Federal Rules of Civil Procedure 13 and 14 relating to counterclaims and cross-claims and third-party claims to see the extent to which this basic concept has been codified. Finally, I want to touch just briefly on the whole notion of case or controversy, because the federal courts will not exercise jurisdiction over a matter that is not, in the definitional terms used by the federal court, an actual case or controversy. Again, this is an enormously complex area. There are cases that, and volumes of treatises, again, that talk about what an advisory opinion is, when people have standing or lack standing, when an action is collusive, when it lacks justiciability, whether it's ripe or not. And the most important thing for you to realize if you've had primarily experience in the state courts is that in the federal courts this is largely a constitutional question, not just a discretionary question. It's an Article 3, Section 2 constitutional question. And the case law that has developed and been generated in that area, much of it largely in the civil rights area, is terribly complex and subject to great change, particularly depending upon the constituency of the United States Supreme Court. In any event, on both of these areas, if you think you have a problem or a question, I suggest in this area, and really in this area more than any other, you do seek some advice from someone who's had substantial federal litigation experience. Now that we know just something about the claims that can be brought, let's turn quickly to the parties and what the rules are in federal court as opposed with respect to parties, who can be sued, and also where the actions can be brought within the federal system. Douglas?
Let me begin this by saying that one of the reasons why thousands and thousands of pages have been written about jurisdiction is that it is often the most fundamental aspect of any given case in federal court. And you should know that where jurisdiction is a hotly contested issue, the court has broad discretion and may actually have a plenary hearing of its own to determine whether jurisdiction is proper at all, whether it has subject matter jurisdiction or whether the right parties are before the court. Let me ask you, we won't cite a lot of cases, but there is one case I will cite to you because it has some useful teachings in it. The name of the case is Data Disk versus Systems Technology. Data Disk versus Systems Technology. It's at 557 F. 2nd 1280. 557 F. 2nd 1280. It's a 1977 decision, an opinion in the Ninth Circuit, but it still holds true today and describes the broad discretion that a district court judge has in determining jurisdiction at the outset, and suggests that from a defense point of view particularly, an interesting strategic issue, if you can separate jurisdiction from the merits of the case, is to ask the judge to address jurisdiction first, combine discovery to jurisdiction, to have a hearing on jurisdiction, and the judge may determine that there is no jurisdiction for one reason or another, and the case would then be out of federal court. This is a good case to study, and it suggests a strategic move as well as some prophylactic measures the plaintiffs might take in order to avoid this. Venue is not the same as jurisdiction. We all know that. Jurisdiction is about whether the court has authority over the subject matter of the case or the parties in the case. We learned that in law school. Venue is about assuming that jurisdiction is there. Is it in the right court within the jurisdictional sphere? And very often, again, this is a fundamental issue in federal court. There are two types of venue. One is the general venue statute, and you will find that at 28 U.S.C. 1391. And this statute governs, as Steve has already said, diversity, federal question, and the issue of corporations. We know now that corporations often have more than one place of citizenship for purposes of diversity jurisdiction. What that means is that they're easy to find, but that you don't always have jurisdiction once you've found them. So that raises an interesting issue. Then there are special venue statutes, and they are cited, if you look at page 16 of your written materials, they are cited there, and I won't go over them in any detail here at all. There is a difference in result between improper venue and inconvenient venue. If you have been involved in a case in which venue is determined to be improper, and the court transfers the case to another federal district court, know that the law of the transferee court, in other words, the court that was proper in the first place, will be the law that applies. This is particularly important when, for example, there are pendent state claims and state law might come into play in your case. If the venue is inconvenient, in other words, it was okay where it is, but it's more convenient somewhere else because perhaps more of the witnesses are there, then the law of the transferor court, where the case was originally filed and was convenient, that law applies. So there's a difference in result when venue is moved for one of those reasons. You should know that the federal courts anticipate the issue of indispensable parties, that is, parties without whom the case cannot be fairly litigated. And to see how that is handled, refer to Federal Rule of Civil Procedure 19. FRCP 19 will tell you about indispensable parties. Also know that the federal courts anticipate the handling of complex cases that may be pending in many districts, but involve common issues of fact or law. You've heard more than once tonight already that the federal courts anticipate big cases, sweeping everybody within the ambit of one court and resolving all the issues and not leaving a lot of things open to chance. This is an example of that. Look at 28 U.S.C. section 1407. 28 U.S.C. section 1407. This statute covers what's called multi-district litigation. Situations where the same law, the same facts, the same people are involved, but for some reason lawsuits have been filed all over the country. The Chief Justice of the United States Supreme Court appoints a panel that's called the Judicial Panel on Multi-District Litigation. It consists of 7 circuit judges and 7 district judges. And upon a motion that's made to that panel, they will determine whether this is indeed multi-district litigation, and if so, what district will handle it for pretrial purposes. There are special rules for pleading and practice in front of the panel on multi-district litigation. You should be aware of those rules. And you should also be aware that the appearance in front of this judicial panel is very, very important, because if you have filed a case in the Northern District of California and your case is transferred to Minnesota, you may have effectively lost control of the case, and the rights of your client may very well be impacted by other attorneys in other parts of the United States. So this is a very key issue, and one that if you can anticipate it and get a motion on to the judicial district, the judicial panel early, it behooves you to do that.
Now that we have some idea of how a plaintiff might choose federal court, the question comes up, what about the defendant? What about the whole notion of removal? What if you're a defendant and you think the case could be, and you would like to have it litigated in federal court? How do you get it removed from federal court? And Boris is going to talk to us about that.
For many of the reasons that the other panelists have talked about tonight, defendants will often, not always, but often prefer to be in federal court. You need unanimity among the jurors. You have generally more conservative veneer